Henry, Joe Catnese.
Here.
Jeff Crubb.
Here.
Carly Neubauer.
Here.
Josefa Rojas.
Here.
Andy Kaplan. Linda Hunter.
Here.
Suzanne Ludwig.
Here. And the floor is still open for public comment. Is there anybody else who'd like to speak? Step forward.
Miss, can you raise your right hand, state your name, spell your last name for me, please?
Last name is Kyle, K-E-I-L. First name is Kimmy. I live in North Brunswick.
Do you swear to tell the truth in this matter?
Yes.
Please proceed.
Yes. So just before we start, Mr. O'Neill, would you mind if we took your exhibits down? I don't know if anybody else, but it really blocks the see.
Sorry, it was an oversight.
I'm friends of John Mills and David Drinkwater and Jen O'Neill and her husband, Alejandro. I've known them for 30 years. I've gone to Vine Street hundreds of times. And I just want to say, you know, imagine a 4-story building going smack up against your property. The light will be gone. Their backyards are beautiful. They are the citizens in your town that you should be very proud of. I want you to consider that piece of this. It's like Target going up next to your house, smack up to your house, and what this is going to do to the quality of their lives. I just want you to consider that. You know, the parking is one thing, but there's also this quality of life issue. The front of the building looks just fine, but look at what the side looks like and the back looks like and the size of it. It's just going to make their lives horrible. Thank you.
Thank you. Does anyone else want to speak? Please step forward.
Miss, can you raise your right hand, state your name, spell your last name for me, please?
Cassandra Oliveras, Oliveras.
And do you swear to tell the truth in this matter?
Yes, I do.
Please proceed.
I will be very brief. I have a comment more than anything. I agreed to the application that's set before us, and I too am very close friends with the residents of 13 and 15 Main Street, and I have recently relocated from Manhattan, from New York City. I'm a resident of Highland Park, and I'm a graduate student at Rutgers. The only interaction or any kind of intersection with DevCo I've had this year was a video that I got in my inbox of the top hit Happy, that song, I'm happy, and everybody's dancing. And it consists of all of these students dancing in front of these properties and empty lots being redeveloped on the Rutgers campus. I am not one of them. I wasn't in the video. I'm not offended that I wasn't in the video, but I wouldn't be in the video because I went to Rutgers 15 years ago, and now I'm back in the capacity of a graduate student there, and it is a place that I don't recognize. And when I came back to the area, and I was here from Manhattan, and I was here from Manhattan because I thought, you know what, I want to come back to the New Brunswick area because I dream of having space again, sidewalk space, parking. I dream of the character and the history and the richness that this town represents, that this city embodies and has embodied. And I heard about a 4-story, 52-unit property going up next door to these homes that I visited. And if you've never visited them, you wouldn't know that they have pristine gardens and incredible character and incredible warmth that you would not believe existed in the heart of downtown New Brunswick, and how much of a treasure that represents. And so I feel that the McDonaldization of Main Street that this property puts forth saddens me, and it concerns me. And if I come back from my PhD, perhaps 15 years from now, I'm relatively certain that it may be, if these kinds of projects keep moving forward, may be a place that I even scarcely recognize at all. And that's my comment.
Is there anyone else from the public who'd like to speak? Please step forward. Oh. Please don't.
I'm so sorry.
Okay. Oh, and gentlemen, if you'd like to take your jackets off, that would be fine.
Sir, can you raise your right hand, state your name, spell your last name for me, please?
George Dawson, D-A-W-S-O-N.
And do you swear to tell the whole truth in this matter?
Pardon?
Do you swear to the whole truth in this matter?
Definitely. I swear, yeah.
Please proceed.
George Dawson, I'm chair of the Brunswick Historical Association in the city directory, which is an advisory, maybe poorly named, but it's an advisory board to city agencies on historic matters. And its duties are spelled out in the municipal code, administrative code. I'm speaking as a chair and not as for the association, since the association has not considered this application. But I feel compelled to offer use my knowledge of historical practice to give advice to the panel here. And I obtained copies of Dan Saunders' letter to John Mills and Jennifer O'Neill from the Historic Preservation Office. And I regard it as a serious document, and one that should be addressed by the board in this decision. It finds eligible for registration on state and national historic register of historic places not directly defined, but a Mine Street historic district, politically extending from College Avenue up to numbers 65 and 70, and eligibility in the HBO's determination, eligibility because of its architectural distinction. It serves to protect the properties from anything which would follow from registration if it's duly appropriately nominated for registration in these by these bodies. Registration, of course, bear in mind, does not mean that the owners of contributing properties in a historic district cannot do what they want with their property as long as compliance with city zoning, planning, building codes. But it does protect them against encroachment by a public entity, be it cities, county, state, or federal. And I can't really define encroachment. It generally is held to mean you can't build a highway through it, you can't put a public park in it. And you can't get waivers of that if you apply to one of the panels of the Historic Preservation Office for a waiver. And public buildings which are registered are changed. For instance, the Roosevelt School in downtown Brunswick is a registered building, contributing property of the Livingston Avenue Historic District. And it's being renovated or it was planned to be renovated. I don't know whether haven't started work yet. Within certain confines, but their renovations protect the facade of the building, but as a public agency, the state schools construction agency, had to get approval of the Historic Preservation Office for any reservation plans that we intend to impart in that building. So I would say the finding needs to be addressed in the board's decision, and whether it complies with, or appropriately overrides the finding of architectural distinction for various reasons as spelled forth in the decision. But you shouldn't deny it. You shouldn't just ignore it and say nobody will pay attention to it, because they will be paid attention to. Thank you.
Thank you. Is there anyone else from the public who'd like to speak?
Do I have to swear?
I think you're up. I thought he was sworn in before.
Say his name for the record again.
Anthony Larabina, Larobina.
Just out of curiosity, as a matter of point, Madam Chair, I mean, he's already provided public comment. Are we permitting multiple comments to be made? I'm just curious to understand how we're proceeding. He's already spoken to
Right, that was asked in the beginning, and that was said yes to.
We did say that it was
Okay.
vacant.
So I have a question for Mr. O'Leary. I believe that's his name. Is the gentleman testifying about the parking?
that.
Olivo?
Olivo, I'm very sorry. So, Mr. Olivo, the enterprise car share that you mentioned before, is that to be used by the public or just by people in the building? And if so, do you have a contract set up with Enterprise to provide the car share just for the occupants of the building?
I can't speak to the contract for this particular project. The applicant can perhaps speak to that in more detail. My understanding, though, is as using car share with the property owner or manager of the property does is they contract directly with Zipcar, Enterprise, whoever provides the car share, and they provide that opportunity for the residents of the building.
So solely for the residents of the building,
That would be my understanding, yes.
I mean, not for the general public?
Correct.
And then I guess that's all I have for you.
Okay.
And if I can ask the applicant, is this enterprise car share going to be solely for the occupants of the building?
That,
I can comment. It has not been contracted yet.
Okay.
No. We need to get through this first, and then we can contract with Enterprise. We're talking about a process which is about 1.5 to 2 years away.
So it is possible that it could be publicly used by everybody else at Rutgers?
That's absolutely possible. And if it is, and if we need more spots, we will provide more spots.
Okay. And then how many bike stalls are you going to provide in the building?
It's on the plan. I don't remember the exact number.
I think the number may be 30.
25, 30.
And speaking again to, or back to what Mr. Credible said, if the car share is open to the public, will that invite people that maybe don't belong in the building into this parking garage where they could do whatever they want kind of thing? Another question about the parking garage, will it be monitored by closed circuit TV? Is there any kind of security measures in place to prevent somebody or at least deter?
Yeah, let me just comment, because we've heard quite a bit in the last hour about this. We've been building these kinds of facilities for, at this point, I think it's close to 7 years, with underground parking garages, 66 Sidecar, 130 Easton, 32 Union Street, 100 Hamilton Street. We have yet to have one incident in any of these garages. So all this talk about attacks and terrorist attacks and explosions, I've heard that before as well. We have not experienced any of that. So all I can give you is my experience to date, which has been nothing but positive.
I would mention to the board that 2nd Street, Hamilton Street, they're different from Line Street. I am also concerned about providing a haven for people who wish to do ill good, and just because it hasn't happened. I asked, is there going to be closed circuit TV?
It's a fair, like you said, it's a fair concern. Again, I can only speak to our experience. Our experience has been that these properties have not been a haven for attacks. They've not been a location where incidents have occurred. We do have security cameras in all of our locations. We have lighting in all of our locations. Do we sit and watch the cameras? No, we're not a security service, but we have cameras available to review if necessary. So again, all I can say is the past experience has been only positive.
And that concludes my questions about security, which I think you answered.
Oh, there's plenty of other security features in the properties as well,
Okay.
from lighting and doors and locking systems.
Well, yeah, I'm sure there's
Yeah.
doors and stuff.
Yeah. Secure doors, not your typical doors that you find in your average house in New Brunswick.
Okay. I do feel, to add on to Mr. Dawson's testimony, that this building, the plans for this building, I mean, even in the picture of the plans, you can see that the building clearly encroaches on the other buildings around it. It is quite large and imposing, and I think that will definitely take away from the historic relevance of Mine Street and the look of Mine Street, the feel of Mine Street. Again, I asked you as a planning board, people pointed to protect our city from outside entities who don't live here from coming into our town and McDonaldizing it. I mean, that's what I see when I see a lot of these buildings that have been put up, and the applicant did mention a few of them. Quite boxy with the sign, just siding everywhere. It's not attractive at all. So please, as the planning board of New Brunswick, keep New Brunswick nice.
Is there any other public comment?
Sir, can you raise your right hand, state your name, spell your last name for me, please?
Glenn Ollendorf, Ollendorf.
And do you swear to hold truth in this matter?
Yes.
Please proceed.
First I want to just apologize right away because I had some personal issues that prevented me from doing the preparation that this hearing deserves, but I want to try and do the best I can. I'm very concerned about whether the board is following the criteria required by law for deciding the parking variance. Mr. Kelso, last spring, representing the developer, commented on a provision in state law that requires all residential development improvements must include adequate parking for residents and visitors of the building. And Mr. Kelso claimed that this board has the legal power to grant a variance making an exception to that rule. And Mr. Buca, the board's attorney, agreed that the board has that power. And I complained that that's the opposite of what the law says. The law permits an exception to the numeric formula that the law sets forth, but it does not permit an exception to the general principle that there must be adequate parking for residents and their visitors. And I'd like to know if the board's attorney, the new board's attorney, Mr. Buca was the old board's attorney, and he's now disqualified. Is it Mr. Ahill? Is that the correct pronunciation? Is Mr. Ahill going to contradict what we were told by Mr. Buca and Mr. Kelso and acknowledge that this board cannot grant a variance unless it will provide for adequate parking for residents and their visitors?
Parking variance that's the only variance that this applicant is seeking, and my advice to the board would be that it has the power under the municipal land use law to grant such variances as are requested and as are supported by the facts.
Is there any legal criteria that the board, that has to be met by the variance in order for this board to be able to grant it?
I think I just stated so.
Well, you just said it has to be supported by the facts. You didn't say anything about the law, about boundaries that the board has to work within, so that if the variance falls outside the boundary and doesn't meet those legal criteria, it has to be denied. If, for example, if the variance does not provide adequate parking for visitors or for residents, are you advising the board that they can still grant it if they see fit, even though they don't have convinced it will provide adequate parking.
Mr. Ollendorf, I don't believe that the board has had an opportunity to deliberate about the application and granting or denying the variance, so it would be premature for me to advise the board on what it can and cannot do. They can certainly seek my advice, but until they choose to act, I don't have any advice that I can give you.
I'm asking, if Mr. Buca has already advised the board that they have the power to grant a variance, even if it will mean that there will not be adequate parking. And that's nothing to do with the specific application. That's simply an assertion that he made about what the law says. So you don't have to hear the application to answer that question. It's simply a question, what does the law say? Does the law limit the board? Can they grant any parking variance that they think is supported by the facts? Or must there be adequate parking?
I think I've answered the question, Mr. Ollendorf. I'm not going to get...
I didn't hear an answer.
I'm sorry that it's not to your satisfaction, but do you have any comments on the application or any questions for the witnesses?
Well, based on so you're not going to distance yourself from what Mr. Buca said.
Can you move on to your next comment, please? He's answered your question.
All right, well, I think he's refused to answer it. I think that would be a more accurate way to put it. Then there's another concern that I have. I'm concerned about the integrity of the process here. You know, the previous mayor of New Brunswick, John Lynch, went to federal prison in part based on pleading guilty to a charge of taking bribes for manipulating planning and zoning board approvals. And that crime, by its nature, implies he didn't act alone. There had to have been a network of corruption that gave him the ability to buy a planning board or a zoning board. And my question is, has anything been done to roll up the rest of that network of corruption to make sure that it doesn't compromise a hearing just like this one?
Mr. Ollendorf, no one can answer that specific question here.
Mr. Kelso can. He's the chief legal advisor. Excuse me, let me finish. He's the chief legal advisor to the county prosecutor, who is the chief law enforcement official of this county.
Your comment has nothing to do with this application.
It certainly does.
It does not. Please move ahead with another comment.
If the planning board can be bought, then that affects this application.
Please move on.
Mr. Kelso is the chief legal advisor to the county prosecutor. And it seems to me that it's a fundamental problem for Mr. Kelso to, that's his day job. It's a big problem for him to come in here as his night job and represent a developer in front of the planning board. Especially since apparently nothing's been done to roll up the network that allowed Lynch to buy a planning board or a zoning board.
Okay, your objection has been noted. Do you have any other comments?
Well, it seems to me that there's a number of indications that link what's going on here tonight to John Lynch. And they don't prove anything, but I think they do prove that a reasonable member of the public could reasonably doubt that the board will be able to proceed fairly and impartially as required by law. And I'd like to point out what some of those connections are. I'm not sure, though, if the instructions I've got to move on exclude that. Well, I'll continue, and I guess you'll stop me if I'm...
Go ahead.
It seems to me that one of the important connections is that the next mayor after John Lynch was William Cahill. And he's the cousin of John Lynch. And everyone here, everyone on this board, and the planning board attorney, you're all here because Cahill appointed you. That's a disturbing connection. And another disturbing connection is that Mr. Kelso, sitting right here, representing the developer, wrote a letter to the sentencing judge asking for leniency in the sentencing of John Lynch.
Mr. Lynch has nothing to do with this application.
Well, but remember, if there's a network of corruption around him that enabled him to buy a planning or zoning board, there's a danger that he may very well have something.
There has not even been an accusation that that has happened with this board.
But Lynch pled guilty.
He has not been mayor in this city for a very long time.
But this happened, he pled guilty about 8 years ago, 7 years ago, to things that happened after he was the mayor.
And none of them have anything to do with this board or this application.
Well, but I have some indications I'd like to point out that perhaps it does have something to do with this application. In order for the planning board to function properly, we need to have a criminal justice apparatus to keep criminals who might buy a planning board away from the planning board.
Madam Chair,
Yes,
if I may.
please.
Mr. Ollendorf is limited to comments or questions of the witnesses that were already present here or comments about the application themselves. The chair is well within its right to cut off the floor if she believes that this is nothing more than a diatribe about completely unrelated issues, unless Mr. Ollendorf can get right to the point, which is apparently there's some sort of a connection that he'd like to make with this application and Mr. Lynch.
If you can make a connection, please do it briefly.
I have a number of connections that I can point out, and I just want to make sure it's clear that the reason is that I think it points to the need for further investigation.
Please make your connections.
One connection is Mr. Kelso co-owned a condominium with Mr. Lynch. I believe that is
This has nothing to do with this application. If you don't have any points relevant to this application, please step down. No,
Can I explain
no,
the relevance?
it has nothing to do with this.
If you don't let me explain the relevance, then how can you judge the relevance?
What you're saying has nothing to do with this application. You're not making any points. You're not connecting anything.
You're not letting me.
Please move forward
You're not
or
letting
step
me.
down.
You're not letting me explain the connections. You're prejudging. Why don't you hear it and then decide? Why not?
Can you make the connections briefly then? You're not saying anything.
Well, you're arguing with me and shutting me down. I'm trying to point out what these connections are. And yes, they're very limited, but the point is...
Make the connections to this particular application.
Well, a man named George Zoffinger is the chairman of the board for DevCo. This is a DevCo project. DevCo transferred the development rights to its subsidiary, College Avenue Redevelopment Associates, and then they transferred it to the applicant, Construction Management Associates. Now, Mr. Zoffinger wrote a letter to the sentencing judge for John Lynch asking for leniency for John Lynch. So that's another connection.
But we have no connection to Mr. Lynch with this application.
But you're
so, do you have any other connections besides Mr. Lynch that you want to make?
You're all connected through William Cahill. You're all appointed by the cousin of John Lynch. Right?
Madam Chair, if I understand his objection, his objection would be one of jurisdiction, indicating this entire board by virtue of the fact that Mayor Cahill, and I'm not sure if Mayor Cahill appointed all of the members of the board, are somehow disqualified from hearing the application. Am I correct?
I wouldn't put it that way.
Well, I'm trying to get to the heart of the matter, so maybe you can put it the way that you want me to understand it if that's not the way that it's supposed to be. Because quite frankly, I think I've given you the benefit of the doubt and made this the broadest possible objection that you could make. Is there something more specific that I'm missing, Mr. Ollendorf?
Yes, yes.
There is, and it has to do with this application?
Yes, and it has to do with Mr. Kelso.
Mr. Kelso's not the applicant.
I know, but he represents the applicant.
We're well aware of that.
And he also represents the county prosecutor, who is supposed to be policing this board to keep it clean.
Madam Chair?
Yes.
As I understand it, and I'll try to be as succinct as possible because I think Mr. Ollendorf, if given the opportunity, will take us on a historical tour that will span generations, perhaps. As I understand it, not only is it because the members of the board are somehow affiliated with Mr. Lynch through their connection with his nephew, who is the mayor, but Mr. Kelso is also apparently, in some regards, the person in charge of any criminal prosecutions in this county. If I may finish, Mr. Ollendorf, if the basis of Mr. Ollendorf's objection is that somehow criminal prosecution is somehow precluded and this board can continue to act illegally, there is the state and the federal government and law enforcement, investigative and enforcement agencies that oversee even them. So I would respectfully submit to the board and Madam Chair that there does not appear to be a connection here to this applicant or this application, nor any questions that apparently Mr. Ollendorf or comments that Mr. Ollendorf wants to make about the testimony that was presented on this application. It is a generic jurisdictional objection based upon a very remote connection to Mr. Lynch, who is apparently not involved in any direct way with this application. At least Mr. Ollendorf has conceded that point.
No, you're misrepresenting what I'm trying to say. I don't think that you've accurately described what I'm saying at all. And Mr. Kelso's role here is extremely inappropriate. His day job conflicts with his night job. It's a conflict of interest.
Okay, that objection has been noted. Do you have any other comments?
Yeah. I have other links that I would like to talk about if I'm allowed, but it sounds like you want me to move on from trying to...
Mr. Ollendorf, are those links somehow connected to this board's lacking jurisdiction to hear the application?
I think the answer to that would be yes. But
they have to do with Mr. Lynch?
They're also linked to the inappropriate role of Mr. Kelso.
I think that you've generically objected to the board having any jurisdiction to hear this application because of its connection to Mayor Cahill's connection to Mr. Lynch.
That's not...
And DevCo. And an individual that is somehow related to DevCo. I understand that objection has been noted for the record. I understand that you're also objecting to Mr. Kelso's continued participation for various nefarious reasons that you believe to be nefarious reasons.
No, it's simply wrong for a person who represents the county prosecutor to be involved in this type of a land use dispute. It doesn't matter.
You made that objection clear. It's on the record. Do you have any other comments?
Yeah, well, I'd like to point out that under the law, if the county prosecutor himself tried to do what Mr. Kelso is doing, that is clearly illegal under New Jersey law. And instead of the county prosecutor doing it, his lawyer is doing it. The county prosecutor's lawyer is Mr. Kelso.
You're stating the same objection.
But I'm trying to, I don't think it's clear. I'm trying to explain, make that objection. You're cutting it off.
It's on the record. Your objection is on the record. Do you have any other comments regarding any other?
Well, I'm trying to explain that the county prosecutor's lawyer should not be allowed to do.
You've said it
Okay,
3
you
times,
said
sir.
that, yes.
Okay. I'm assuming that you don't, I'm not supposed to go on with why I think there are links between what's happening here tonight, the possible links that should be investigated and haven't been. That's not something you want me to go into, right?
Does it concern people in this room tonight?
Of course.
Not Mr. Lynch?
Well,
That
I'm talking
objection
about-
has been noted already also.
So links to Lynch and his network
That has been
are
covered.
off limits for me, right?
They have been covered and they're on the record.
And I'm not allowed to go into further details on
You've
those
already
links.
stated the objection and it's on the record. Do you
And-
have any other comments?
You're not going to allow me to support the objection with further detail, correct?
Yes.
Thank you for clarifying that. Okay, then let me move on to why I think that this application is part of a relentless assault on the middle class in the 6th Ward. And I'm including students as well as people who work and live there long term. I think they're all victims in this campaign against the middle class. And one example of how severely harmed they are is that you can't buy groceries at reasonable prices in the 6th Ward. And the reason is because there is such inadequate parking that a merchant can't run an operation that's going to serve enough of a big enough customer base to cover his overhead and charge reasonable prices. So the prices are sky high. And that means that students who come into these buildings, this 17 Mine Street building, and the other buildings like it that have been put up by the same applicant and by other developers for many years, they're not going to be able to buy groceries at reasonable prices. They're either going to have to pay huge money to rent a parking space, and they can't afford that, or they're going to have to pay these ridiculous prices to buy food and other necessities. And these are people who are already going deeply into debt to finance their educations. And many of them won't succeed. There's a very high rate of people who have to drop out of Rutgers and other institutions because they can't keep up with the overwhelming financial pressure. And many of them, not only are they borrowing huge amounts of money, but they're also borrowing from their own parents' retirement savings and putting their parents' retirements in jeopardy. And they're being bled dry by these developers who are strangling the community like vampires, building us boxes crammed with people without the necessary infrastructure. Without the parking, the critical infrastructure, people are going to have to spend enormous amounts of money on groceries, or they're going to have to spend enormous amounts of money on parking. They can't afford it.
So your objection is to parking?
Well,
right? That's what you're stating.
That's what the variance is. That's what we're here for, right? It's a parking
Do you
variance.
have any other objections, any other issues?
Yeah. It's not just a matter of the costs that students and everyone else in the neighborhood has to pay, whether it's for parking or for food, but also not having adequate parking limits people's career opportunities and their academic opportunities. The students, many of them have to work in order to be able to go to school. And if they don't have the ability to park, then that can cut them off from work opportunities. And many, people who live in the 6th Ward long term, non-students, they can have the same issue. Many jobs are not accessible by any type of public transportation. A lot of the New Jersey is not New York City. It's many of the best jobs are in suburban corporate campuses where you have to have a car. And also many jobs by their nature, require driving, like a lot of sales jobs require driving. A lot of trades, construction trades, they're going to different places every day. They need a car. A lot of service jobs, they have to have a car to get around because it's part of the job itself. And this, I think that this contributes to this problem of students not being able to complete their educations because of the overwhelming financial burden. And something else I think is very disturbing is that the applicant's experts justified and analyzed the application by relying on a set of standards in the municipal ordinance as to whether or not to grant a variance. And they applied that to the parking variance. But under New Jersey law, the appropriate standards are not set forth in the municipal ordinance. The standards for granting a parking variance are set forth in the ARCIS rules at the state level. And there are various criteria that have to be met in order to grant the parking variance. And they ignored that. In their oral presentations, they ignored those criteria. And Mr. Egdahl, the board's attorney, did not point out that that was wrong. So I'm concerned about that, ignoring those criteria. And I'd like to ask, do you have, do the experts, or Mr. Broder, the applicant, can you give us anything at all to give us some measure? Well, let me ask, how much are you charging people to use the parking spaces in your buildings?
I've testified to this previously. We charge $75 per spot.
Okay. And do you have any basis to believe that college students can afford that?
Yes, I have 20 years experience in this business here, and it has proven that they can afford it when they choose to pay for it. Yes.
The ones who do pay obviously pay, but what happens to the ones who can't come up with the money? How are they affected?
They will choose not to rent from us.
What about the ones who do?
It's called a free market, sir.
A free market?
Yes.
A free market. And the reason we have the ARCIS standards is because we're not supposed to have a free market.
So what would you suggest in lieu of $75? Would $55 be good?
I would suggest that you build the number of parking spaces required by law. That's why I'm here, to oppose your parking variance, because it's not even permitted by law, but even if it was, then I'd be against it because of the consequences. That's what I suggest, that the parking variance be denied. That you should, if you want to build a development, you need to provide the infrastructure. What you're doing is, you're asking for a gift that's worth about $1,500,000. Your own experts value the cost of each parking space to construct it at $20,000 to $30,000. And you're looking to short us by what, 50, 60 parking spaces less than what the legal formula requires. So you're talking about $1.5 million roughly that will be in your profit and loss. And your experts have commented that don't make us build those parking spaces because the cost of building them will be rolled into the rent. And that's going to hurt the poor students and the poor residents. And you've become advocates for students and the downtrodden and the middle class. But I'm a bit suspicious. That's not what would happen at all. Perhaps, and tell me if you have any basis at all to the contrary, perhaps what will happen is the rent's going to be what the rent's going to be in the market. And it's not going to be affected much at all by whether you build the spaces or not. What's going to be affected is your profit. You're here to fight for your $1.5 million. You're not here to fight for the middle class or for students. And I'm asking you, do you have any evidence at all that this is going to be a matter of keeping rent down versus keeping your profit up?
Can I comment?
Sure, please.
Okay. Well, I appreciate your comments. I do. And
Microphone.
I do appreciate your comments. Thank you very much. My only response is very simple. You asked if we have experience, and my answer is yes. We have many years of experience. And you asked me, how can I show that? Well, if you want to ask our tenants what their experiences have been in our locations, you're free to do that. Okay? We have occupancy rates which are close to 95%, almost 100. If our product wasn't there to the standard of what the market wants, then we wouldn't experience that. It's as simple as that.
If I'm hearing you, you're saying, well, we've been very successful at making tons of money. Therefore, we should be allowed to continue doing it
Exactly.
the way we want to do it.
Mr. Ollendorf, do you have any other comments you want to get on the record?
Yeah. I have questions as well for the witnesses. I assume that's permitted?
Please proceed.
Thank you. Is there any evidence you can give us as to, you've justified your application here by referencing other properties you've built with similar or lower parking ratios and your experience. Do you have any evidence as to the number of students who were unable to complete their education because of the inadequate parking or adequate parking? Do you have any evidence as to the cause and effect relationship between the amount of parking you've provided in your other comparable buildings and the educational outcomes for students?
I'm not going to allow me to answer that question. I don't even know how you would possibly try to answer that. And, been pretty tolerant of listening, but that just goes beyond me.
Next comment, please.
No answer.
No answer.
Okay. Do you have any evidence about how the construction of these type of buildings by you and other developers has affected the cost of living in the 6th Ward? Grocery costs and so forth. Any evidence?
Same objection. I don't know how we would even calculate that, or is that something that's responsibility of the applicant in this application?
Next question.
No answer.
No answer.
Any evidence at all as to whether you've harmed the community at the same time that you've made tons and tons of money and been very successful? Any evidence as to how you've impacted the community at all?
We don't have any statistics at all to show how we've harmed the community. That's correct.
Do you have any other questions, comments, objections?
I'd like to sit down and give other people a chance. Perhaps
Are you finished with your testimony?
May I finish for now and perhaps come back?
No, the public portion is going to be closed soon when everyone's done speaking.
I was given that permission. Yeah, you was able to speak quiet.
Madam Chair, I would like to ask a question, Mr. Ollendorf.
Sure.
Before he leaves.
Sure.
Mr. Ollendorf, do you own property in New Brunswick?
No, sir.
Did you own property in New Brunswick?
No, sir.
Okay.
Oh, I almost forgot. I am actually looking for housing. And one of the problems I ran into is that I encountered many rentals where I couldn't get a parking permit if I lived there because the landlord had waived the right of any tenant who lives there to get a parking a street parking permit. So if I lived there, I wouldn't be able to park on the street. And I also, if I lived in one of those buildings, I wouldn't be able to park in the parking lot on site either, because I was told that all the spaces are taken, and we have a very long waiting list. And that includes buildings owned by the applicant. They told me, we got no spaces, it's not possible. If you want to live here, you're not going to be able to park. That's very alarming. I was also told there's no visitor parking. And this comes directly from Tina Caputo, an employee of the applicant. We got no visitor parking. And there was even a misunderstanding where they thought that I had a wheelchair. Just to clarify, I'm complaining that there's clearly not adequate parking for residents, clearly not adequate parking for visitors, no parking for visitors. But then there's a third problem. They thought I had a wheelchair for some reason. It was a misunderstanding. Maybe they confused me with another potential tenant. And I was told a person in a wheelchair isn't going to be able to live at a particular building because there's no place for a visitor to park, and there's no open parking space that can be given even to a disabled person. And I was told not only would I not be able to live there because of my wheelchair, which I don't have, it was their mistake, but a person in a wheelchair wouldn't even be able to visit just to see what the property looks like, because there's no place for the visitor to park, and there's just no parking. And then how's the person in the wheelchair going to get there? So it seems to me that in addition to the problem with not adequate parking for residents, no parking for visitors, a third problem with these cubes is that people on wheelchairs, and perhaps with other mobility limitations, are being systematically discouraged and excluded by the lack of parking, that the grossly inadequate parking provided by this applicant and other developers like him disproportionately impacts the disabled, people with physical mobility problems. And I think it hurts everybody, it hurts the entire community, but that is a special subpopulation that's getting hit even harder. And I think it's reprehensible. And I mean, I think, and I'm getting close to sitting down now, reserving the right to come back, perhaps. I'm not saying I will, I just want to keep the options open. But it seems to me that he's pointing, their fundamental argument is they're pointing to their experience with similar properties, and yet there's no evidence at all, and that they made a lot of money, but they're not giving us anything to show that they haven't had a terrible, terrible impact on the community and on the mission of the educational institutions there, on people's career developments, academic developments, on people's retirements, on people's health and safety. There's nothing. There's just saying, we made a lot of money. We made a lot of money isn't good enough. And I'd like to remind you, I mean, and Mr. Olivo, in his written submission for the original application, did quote at length the criteria in state law that you're supposed to be using. But nobody has talked about it orally. And would you mind if I just point out what some of those criteria were?
No, go ahead.
All right, I guess I just got to find.
Excuse me, can I just ask, is this something that was presented during this October 14th or this evening's meeting, or is it something from the past that we're not going to be considering anyhow?
Can you answer that question?
I don't understand the question. When you say this, what are you referring to?
Well, you're referencing something that was a written submission from the old application, and it's my understanding that October 14th and tonight is a new hearing. So I want to make sure that it's evidence that we're supposed to be considering as part of this hearing.
It's not evidence, it's the law that you are required to follow.
Well, you cited Mr. Olivo, though. That's what I'm concerned about. If you're going to read from the statute book, that would be a different thing. But I think Mr. Olivo's testimony would only be relevant if it's from October or November's meeting.
Mr. Olivo quoted the statute at length, not the statute, the ARSIS rules at length in his February 28th written submission. The only reason I didn't bother to print out a copy directly from the administrative code, not the statute, it's administrative code, is because he's already gotten the language in his written submission. But I could just as easily be reading it to you directly from the code book. Either way, the point is, he himself in writing admitted these criteria govern your decision. And it's in all of the applications, any application for a parking variance, not just that one.
I'm just concerned that we deal with the testimony that's been provided during this hearing. The first part and then the second part tonight. Because as a board member, it's my responsibility to vote based on the presentation of evidence that was presented at the hearing that we're dealing with. Not February, not March, not June or July, but October and November. And I want to make that clear to my fellow board members that we are addressing this from the standpoint of testimony that was given in October and again tonight in November. And that's it. That's all I'm asking.
I'm trying to present what the law says. It's not testimony, it's law.
Well, I would then prefer that if you know the council wants to guide me accordingly, but I would prefer that you actually read it from the administrative code than to quote somebody who hasn't testified about it in this particular hearing.
Well, he's quoting, he has paragraph
But that's from
italicized.
February, and this hearing started new in September.
But it's the law. It's the
But
law.
Then quote the law.
That's what I'm about to do.
You're going to quote what he said.
Don't quote what Mr. Olivo said, just quote the law. If you have the administrative code in front of you, read it. I don't really care, but I'm just concerned that I don't want anybody to accuse us of mixing testimony from a prior hearing that we're not going to consider with the testimony that was provided in this particular hearing.
I'm not presenting testimony. I'm trying to just point out what the law says. I'm not even asking to read it to you because I don't want to take your time. I just want to point out a few of the points that are there. If you want, I'll read it to you verbatim.
I would just try to be helpful here.
Okay, go ahead.
Because I'm familiar with the submission that he's referring to, which was, I think, an attempt to identify, clarify RSIS requirements. If in that letter, if it's quoting what this administrative code says, I really don't have an objection if he's reading it out of that letter if it's going to save a little time, because I'm sure what he did was cite what the law was.
Somebody just handed me the administrative code, so I can now read to you what the law says without looking at Mr. Olivo's submission.
Thank
Does that
you.
make you happy?
Yes, it does. Absolutely.
That's wonderful.
Mr.
Okay.
Ollendorf, if I may, Madam Chair,
Yes.
what's the citation that you're reading?
Let's see. I think we would
What's the
start.
code section?
NJAC, Title 5, Chapter 21, Section 3.1. Let me,
He's there. Is it the right section?
yeah, 5:21-3.1. The title is Exceptions. Instead of the variance, it's really an exception, a de minimis exception. That's the terminology used in the code. And I can either go quickly through and just point out the criteria, or I can read it verbatim, whatever
Read
makes
it.
you happiest.
Read it verbatim.
Okay. The municipal approving authority may grant by resolution of the planning board or zoning board of adjustment such de minimis exceptions from the requirements of the site improvement standards as may be reasonable and within the general purpose and intent of the standards. If the literal enforcement of one or more provisions of the literal enforcement of one or more provisions of the standards is impracticable or will exact undue hardship because of peculiar conditions pertaining to the development in question. An application for an exception pursuant to this section shall be filed in writing with the municipal approving authority and shall include, by the way, can I skip a couple paragraphs that aren't relevant? You want me to go verbatim? Huh?
You can skip.
Okay, I'm only going to skip paragraphs, not words, because I think that's what you want.
Okay.
Okay. There's some procedural things I'm skipping. Examples of de minimis exceptions include, but are not limited to the following: reducing the minimum number of parking spaces and the minimum size of parking stalls, reducing the minimum geometrics of street design, such as curb radii, horizontal and vertical curves, intersection angles, centerline radii, and others, reducing cartway width, and any changes in standards necessary to implement traffic calming devices. The municipal approving authority's granting of a request for a de minimis exception shall be based on a finding that the requested exception meets the following criteria. So it is consistent with the intent of the Site Improvement Act. It is reasonable, limited, and not unduly burdensome. It meets the needs of public health and safety, and it takes into account existing infrastructure and possible surrounding future development. And I'd also like to, last thing before I sit down for now, is I have a funny feeling that people here don't know what the term de minimis means. And I would like to read a definition from a law dictionary of that term. From the not a law dictionary, from the Merriam-Webster dictionary, de minimis, lacking significance or importance, so minor as to merit disregard. How the hell can going from 96 parking spaces down to 43 be de minimis if you think about what that means? De minimis. I'll sit down for now. Thank you.
Thank you.
Just for clarification to the board, I think if the board is going to consider, they need to consider all of the provisions under RSIS, including those that I specifically pointed out in the May 27th letter, which is now part of the record.
I can't hear what he said. Can you say that louder, please?
Due to the time, the meeting will be adjourned tonight, and we will pick up with public comment at the next scheduled meeting, which is December, I don't have the date in front of me.
December 9th.
December 9th, will it be in this location?
Yes, I've talked to the clerk for the freeholders and tentatively reserved this room. It's available, so I'll confirm those. So we would meet back here December 9th, 7:30 p.m.
Did everyone hear that? December 9th, 7:30 p.m. at this location.
And I assume that no further notice or publication is required now.
Yes.
Is there a motion to?
I'll make a motion to adjourn.
Second.
All in favor?
Aye.
Opposed? Meeting adjourned.
Adam, I want to thank you for your insights and helping my kids. Well, I'm not going to talk. That's all. Here's some cards.
He did the same.
Hi, Rita Gardner. Sorry about